number 18, the people of the state of New York versus Norman Whitehead. Counsel?
Good afternoon, Your Honors. My name is Matthew Hugg. I represent the appellant Norman Whitehead. I would request 2 minutes for rebuttal.
You may have 2 minutes, sir.
Your Honors, I think that the case law is clear with respect to what I guess I'll term dry possession prosecutions. In other words, criminal possession of controlled substance charges in which there is no evidence to support either the weight element or the identity of the substance.
Well, it's not no evidence, right? There's no drugs. So the question, I think, really is, what's the evidence that there were drugs, right? Because the rule is not, and this court has never held, that you need the drugs to convict on a possession charge.
I would agree, Your Honor, with the way that you framed the question. The way that I look at it is when you're looking at cases involving intercepted telephonic communications, the courts repeatedly use the phrase other evidence. Other evidence meaning the evidence, the actual evidence, because if I tell you...
What about testimony of people involved in the alleged drug sales? Is that other evidence?
There are cases in which it can be considered other evidence, Judge, but you don't have that here. Certainly you don't have that with counts 225 and 226.
But you had cooperator testimony, no?
With respect to 225 and 226, no, you do not.
Well, so what's the only evidence they put forward on 225 and 226?
225, as I see it, they tried to do this kind of roundabout dance in which they say and they allege, their evidence is pretty sparse with respect to even this, but they say that the defendant arranged on January 25th to go down to New York City to meet with Mr. Williams. While he's down there, he's alleged to have sold a quantity of cocaine to a Mr. Goodson in New York City. They presume that Mr. Whitehead returns to Schenectady with yet more cocaine, though they present no evidence to support that. And then 2 days later, Mr. Goodson returns to Schenectady apparently, and lo and behold, he says, while I was down in New York City, I sampled a little of that on the 25th. Therefore, the defendant must have had some more cocaine, the same batch that I sampled back down in the city.
It sounds like you're arguing that they actually needed direct evidence of this one. Of course, they could have done this through circumstantial evidence. We could be looking at what are appropriate inferences. Why aren't there appropriate inferences that can be drawn? Why can't you connect these dots?
Well, I think that it's extremely thin, Judge. When you look at drug expert testimony, drug user testimony, you will find that in almost all of the cases, it is from a sales charge in which the user, the end user, got it directly from the defendant and can say, I'm familiar with the effects of cocaine. I got cocaine from the defendant on February 27th, which you don't have here, and I used it and it had the same effect.
That's the only evidence in those cases. It seems, I think what Judge Rivera is also suggesting here is you have to look at all of the evidence surrounding the transaction. In those cases, and the one where we had marijuana, where it was a student and we said they didn't have enough experience to do that, that's the evidence. But here you have a wiretap, you have surveillance, you have cooperator testimony, even in those 2 counts, not directly saying I bought the drugs and then I ingested them and I know the side effects of the drug. You had all of that type of testimony surrounding these transactions. So to parse it out and say you didn't have a user here may be true in those particular 2 counts, but we have to look at whether there was legally sufficient evidence in whole.
I disagree, Judge. I don't think that you convict someone because you've got evidence that they did something over here to say that they must have done it also over here. If you look at count 225 and 226, there is no evidence. The evidence is interpretations by a law enforcement officer as to what was being said on a communication on the 27th, allegedly in the county of Schenectady. And the way that they try and tie it to other evidence is to say 2 days earlier, somebody who is a cooperating witness with us said that he sampled a batch of cocaine, some 100 and some miles away, and therefore the defendant still must have cocaine. There's no proof that he still had anything if he was even in New York City with Mr. Goodson. There's nothing to
Other than
substantiate.
his own attempts to cook it to crack, right?
Well, that's interpretation by an investigator that when he said the term...
Again, then why isn't that the evidence that people have presented? The question then is whether or not that's appropriate evidence. So what is wrong with that evidence to let you get to those inferences?
Because I don't think that it's evidence of anything more than just more of telephonic evidence. It's more Martin. You can't keep piling more Martin evidence on top of Martin and say, well, we've got enough now.
But when that telephonic evidence includes statements or potential admissions by the defendant himself, isn't that evidence?
You don't have the types of admissions like you had in the marijuana case, which was...
Well, but when he's talking about cooking it and that sort of thing.
Well, the people point to things like the term Rocky Balboa. But when you look at the transcripts, he's referring to this gentleman as Rocky Balboa. He's not saying, did you get the Rocky Balboa, which Detective Geary says that means crack.
But that sounds like your closing argument. Right? It might be enough for the jury to draw those inferences. Again, I'm asking, why isn't this evidence the kind that can be used to get you to connect the dots on the possession?
Well, I guess a good example, Your Honor, would be a case that the people cite, which is People v. Gaudis, which is 83 New York 2nd, 630, 1994. It's an assault case. Mm-hmm. They cite to it for the proposition that telephonic admissions can form this other evidence. So you have an assault. Now, you have a victim. The victim testified in Gaudis is that the defendant's cohorts beat me up. If you didn't have that, if the victim didn't exist, you couldn't find that victim, and you have a person on a telephone call saying, I beat the crap out of that guy, I really tuned him up, that is not enough to convict the man for assault, any more than if I explain to you right now, Your Honor, I have 8 ounces of cocaine in my bedroom. And you say, well, we're not even going to bother going to your house, we're not going to do anything else.
But that's not all there is, and that, I think that's the problem, is that we're looking at this entire record and putting things together, not each individual thing by themselves.
But you start to, it becomes this nebulous thing, I think, Judge, if you go beyond.
People have been convicted of murder when there's no body, right?
Yes.
Isn't that right?
Yes.
Okay. So and in those cases, isn't it a matter of looking at the totality of the evidence and the inferences to be drawn from that evidence and determining whether there is enough that a rational jury could find that this defendant murdered this alleged victim?
Without getting...
How is this different?
Because in this case, it requires rank speculation, okay? The 225 charges him with having more than 4 ounces of cocaine. And what do they provide besides an interpretation of a call to support that that actually existed and that measure existed? They don't.
Mr. Hugg, on your argument regarding sufficiency as to weight, was that preserved below?
As to the amount? Yes, Judge, I believe it is.
Where in the trial record was that?
I couldn't pinpoint an exact page number, but I presume, it is my presumption that it was included in the TOD, at the conclusion of the people's evidence.
Unless I'm misunderstanding the record, counsel, your client was convicted on 7 counts, and you've only dealt with 2.
Right, Judge. I think those are the two weakest charges as far as the possession go, in my opinion. I think that they all should fall, as I argue in my brief. But I think, obviously, if your honors don't go with me on 225 and 226, I can't see you going with me on the remainder.
Okay.
Thank you, counsel.
Oh, I'm sorry. Thank you. I missed the light.
Missed the light. Counsel?
Good afternoon, Your Honors. My name is Lisa Fleischman, and I represent the state in this action. May it please the court, I'd be happy to take the court through the evidence supporting counts 225 and 226, and that evidence goes well beyond a couple of phone calls.
How do the people prove weight without the drugs?
We proved it through telephonic admissions. We proved it through the eyewitness testimony of Carl Goodson. For other counts within this indictment, we proved it through the eyewitness testimony of Karashan Mansaray. They both said that the defendant gave them cocaine. Both are Goodson is a user. He's a seller and a reseller. Mansaray is a seller and a reseller. They know what cocaine is, and they both testified that the defendant handed them the cocaine. So that's two ways.
So it's your position that we don't need to go through the laboratory process with calibrated scales and determine the exact weight of the narcotics that was possessed or sold?
Absolutely, Your Honor. This court has never held that that's been required, and that's circumstantial proof that we've offered of the existence of cocaine. In fact, this court, federal courts that I've cited to, courts across the country have all held that.
I don't want you to get off track here on this. On the 4 ounces, on the 225 and 226, those are the 4 ounce counts, right?
Yes, Your Honor.
All right. So I thought the proof there was that there was 120 grams that was held out, cooked up into crack, and that's the proof of the 4 ounces.
Correct.
So the 4 ounces comes from the 120 grams. That's where the number comes from, right?
That's correct, Your Honor.
And of course, but that relies on purely on Goodson's testimony, right?
That relies on Goodson's testimony and also on the testimony throughout the trial that shows that the defendant has familiarity with weight. Mm-hmm. He talks about weight with respect. I'm sorry, Your Honor, go ahead.
No, that's fine. I'm listening to you. I'm just mumbling to myself.
Okay.
Don't pay any attention to me, Ignore that man,
We're very
all right.
Go ahead.
The second counts I'm kind of curious about are 228 and 229. On 228 and 229, the proof there is Mansaray, who wasn't a user, doesn't know if he's selling coke or not by his own admission, didn't test it himself just by what he had been told. You have the testimony of somebody named Johnson, right? Who
yes.
said he was pretty sure
yes.
that it was. So you're saying pretty sure is legally sufficient?
I'm saying more than that.
Okay,
pretty sure were the words that Darren Johnson said, and he did testify, Darren Johnson, at trial that he is a user, he's a seller and a reseller. What happened here was Karashan Mansaray, on the day, the 27th, made phone calls and said to people, stuff is pretty dried up out here. I don't have anything. So Johnson calls him, and somebody named Roosevelt Cobb calls him. And Mansaray says, can you hold on? Can you hold on? It's coming this evening. And then along comes the defendant with the half kilo, and Mansaray testifies that he distributed that cocaine to Roosevelt Cobb, another.
So let me stop you. He never tested it. He's assuming it's coke, but he doesn't know it's coke. So he's not sufficient. Mansaray is not sufficient to establish that it's coke.
Right, and we're not relying on his user testimony.
Okay.
It's Johnson's testimony that we are.
And so you are saying that pretty sure, he used it later that evening, that he's pretty sure it was the same stuff. He doesn't know he was smoking it up.
Yes. Pretty sure. We're saying it's almost a certainty that he did have that cocaine from that half kilo. That was the cocaine that Mansaray had. From the nature
Is there
of the
any other proof that you can point to in the record besides pretty sure?
The communications that Mansaray had with.
Let me just stop you just so I'm clear. Telephone communications?
Yes, these are telephone intercepted communications. And Johnson was looking for cocaine at 6:02 p.m. that night, and the defendant came in an hour later with the half kilo. And Mansaray was saying, hold on, it's coming. And he told another person who called as well, making an inquiry about cocaine, and Mansaray said, it's coming this evening. So it was clear, or a clear rational inference that a jury can make from this evidence is that Mansaray had nothing, and then it came in, and then it was distributed. And then we've got Johnson saying he's pretty sure that he sampled Mansaray's cocaine from that evening. He got cocaine from Mansaray that evening. And then he testified as well, Johnson that is, that every time he used Mansaray's cocaine, it was cocaine. So considering all of that together, that is sufficient evidence, legally sufficient evidence, to demonstrate that the substance was in fact cocaine. Moving
At
back,
what point would Goodson's statement be just too uncertain? You say pretty sure is good enough, but at what point is it now just too uncertain?
Goodson was certain. Goodson said that he sampled the very cocaine that he got from the defendant in New York City. And he also, let me back up for a second. With regard to those two charges, somebody mentioned, I believe, Your Honor, connecting the dots. Let me connect the dots for this court. With respect to those charges, Goodson testified that the defendant gave him cocaine on the 25th. The next day, the two gentlemen are back up in upstate New York, and they're talking over the phone, and they're giddy. They love the quality of this stuff. It's wonderful, pure, shiny stuff. Those are the words that are being used. Goodson testifies that he's talking about the quality of the cocaine. It's very clear from the context that the two gentlemen are talking about the very same parcel of cocaine and their respective pieces of it. Because one says, that stuff's so shiny. The other says, yeah, I know, I'm looking at it. Goodson testified that they were talking about the cocaine that they both got on the 25th. On the 27th, the defendant says to Karasham Mansoray, I cooked up $120 last night that I brought back. And a jury can rationally infer that he's talking about the cocaine that he brought back from New York City. He's also talking about that cocaine because he said he cooked it up. And he and Goodson on the 26th were talking about cooking up cocaine. Rocky Balboa, Goodson testified, was a reference to the fact that crack comes in rock form. They also called each other Chef Boyardee, and they made various jokes about cooking. Viewing all of this evidence together, that connects the dots so that any rational jury can conclude that the defendant possessed cocaine on the 27th and possessed it with the intent to sell because he offered it to Mansoray. I'd like to point out a couple of things that were discussed. The legal sufficiency of the evidence of the weight was not a part of the trial order of dismissal. I'd note that that's, I believe, at pages A526 and 527, I believe is the trial order of dismissal. I would ask the court to take a look at pages A518 and 519 and SA 350. That's the testimony of Carl Goodson, in which he explains that he sampled the drugs that that the defendant gave him, and also that when they were talking about cooking up drugs, they were talking about the drugs that they got from New York City on the 25th. So viewing the evidence rationally,
So
viewing...
is a witness who's a drug user, who just gets up and says, I'm a drug user, and says, oh, I know this was cocaine because I used it.
Yes.
How much experience as a drug user does that witness have to have?
You have to lay a foundation. The witness does not have to be an expert. There's no law that requires the witness to be an expert. The appellate division cases that I relied on, the witnesses were not adjudicated experts, but there
Well, they may
has
not
to
be
be...
a scientific expert, but there has to be some basis by which the person can communicate that, in their experience, this drug that they've ingested or that they've been in contact with, they can testify to under oath. Their belief is that it's cocaine.
Yes. What the prosecutor must do is lay a foundation with the witness, and that is exactly what the prosecutor did here.
Right, so that's what I'm saying. So what the drug user says, I've smoked crack once?
He testified, Goodson.
No, I understand.
Yeah.
I'm asking you where to draw that line.
Oh,
Where you draw the line?
I would say
Once, twice,
I would say many times.
years, an
I would-
addict?
Years. Addict for user, I would say, or frequent user, near addict, somebody who has used it in more than a recreational way, perhaps.
Thank you, Ms. Fleischman.
Yes.
Thank you.
Oh, thank you, Your Honor.
You're welcome. Mr. Hugg?
Yes, Your Honor, briefly, with respect to the other possession counts, that being 228 and 229, counsel just acknowledged that Mansoray's alone was not enough to demonstrate that this was cocaine. I would like to direct Your Honors to the respondent's brief at page 66, which deals with Darren Johnson. And what you see is that there's a conversation that's allegedly had between Mansoray and Johnson in which Johnson is allegedly requesting a product or cocaine from Mansoray. Mansoray says, I don't have it. Then the thread is left because there is zero proof. In fact, the proof belies their point that Johnson ever got cocaine that day or, in the subsequent days from Mansoray. Mansoray, according to their brief, says that he sold it to people that were underneath him, like Cobb, William High, and others. He doesn't say, and there are no phone calls to substantiate, that Johnson ever got his hands on any cocaine that came from Mansoray on February 27th, or 28th, or 29th for that matter.
Let me ask you one point, it's on a slightly different topic, and I don't want to forget it. You argue that in the opening, the use of the legal meaning of the word sale was discussed improperly by counsel.
Yes.
Let's assume it was. Why isn't this simply an abuse of discretion standard? What remedy are you asking for?
Judge, I think that I'm asking for it to be reversed and remanded for a new trial.
On that issue alone?
If need be, yes, Judge. I think that so reduced the burden of proof on the people with respect to at least the sales counts that yes, that kind of bottom line of a sale, an offer is a sale is wrong, and the judge should not have permitted it and should have stepped in and given a curative instruction.
But you're saying
Mr.
that
Hugg,
instruction...
you also raised a challenge to the eavesdropping order and the propriety of the eavesdropping order. Do you
Yes.
care to use some of your time to address that?
Certainly, Judge, and the people pointed out that there are some preservation issues with that. I think that the defense pointed out at the very least that the main error that they pointed out was that the March warrant, which would have been the second warrant that included Mr. Whitehead, was based upon both intentional and at least reckless misstatements of fact by investigator Souter, and when he stated unequivocally that he reviewed a video surveillance of a interaction between Mr. Whitehead and Mr. Williams at the Woodbury Commons and definitively saw a large bag containing a white powdery substance. That's false. That was a bottle of windshield wiper fluid. Where it goes into the intentional misstatement of fact was when he said that Detective Plant told me he saw it too when he was there, and Detective Plant testified that that simply wasn't true. So in addition to that, which I think is the more fundamental error, is that the court and the prosecutor kept expanding this warrant, this eavesdropping warrant, through amendment, ultimately through a terminated amendment, making it somewhat like a zombie eavesdropping warrant that just was never going to end, and they were just adding more and more people instead of...
You're suggesting that the order that ultimately authorized going up on the defendant's phone was an amendment? It wasn't a new order to go up on that defendant's phone?
That's exactly what I'm saying, Judge. When you look at the applications and the orders that followed,
I saw what it said, yeah.
they're all amending that initial...
I know what it said, but I'm going to the substance of what it accomplished.
I'm saying yes, it in substance and in form, which, as this court has repeatedly said, that this eavesdropping statute must be meticulously followed and closely read. And if you look at Professor Prizer's commentaries, he specifically, presciently, advised that this is an improper procedure, that that the CPL permits amendment like a plain view amendment. So if I've got authorization to listen to guns and they're talking about cocaine, I can go and I can amend that warrant so I can listen to the cocaine. It doesn't say I can keep amending it and adding 1, 2, 3, 4. Oh, person number 4 is talking to 5. I want to talk to number 5. The procedure is to go
That's
get it.
assuming it's an amendment. Judge Garcia, did you have a question? Okay, thank you, sir.
Thank you, judges.